Remarks regarding the Oregon analysis will also have a relevance with regard to other constitutional theories that have been addressed in the briefs. For there is a common thread here that I think transcends any single constitutional theory, and that is a subtle, or perhaps not so subtle, assault on the notion of non-economic damages and both the jury's and court's ability to render reasonable awards for those type of damages. As I talk further of the statute in light of the Oregon Privileges and Immunities analysis, I would ask the court to keep in mind what the preamble to Chapter 305 says is the legislative intent. It talks about, quote, reduce costs associated with the tort system, unquote, but then it says, while assuring, quote, adequate and appropriate compensation, end quote, for injured persons. The intent was to provide that all injured persons receive appropriate and adequate compensation. This is what the legislature said. It is not what the legislature did with regard to non-economic damages. One other thing the legislature did not do is to change the common law in this state regarding this type of damages. It is a legitimate type of damages in this state. We do not have classes of damages. Non-economic damages are on the same plane as any other type of compensation allowed. Now, Oregon. A full exegesis of the Oregon Privileges and Immunities analysis is not possible here. But if we accept Professor Schumann's distillation as accurate, Oregon has said if you have a true class, and they divide the Privileges and Immunities analysis, as you know, into true classes, pseudo classes, and individuals, and provide a separate standard for each, according to the professor. If you have a true class and what is called invidious discrimination, or the alternate phrase being stereotyped prejudgments, then you have a per se violation of the Constitution. No balancing. Simple, straightforward test. Now, while there may be some basis for suggestion of a true class here, insofar as age or marriage criteria rendering those classes suspect, even if you accepted Professor Schumann's pseudo-class analysis, and defined that pseudo-class as all those who have suffered severe non-economic damages, we suggest that if you find the equivalent of invidious discrimination in some form of prejudicial stereotyping inconsistent with fundamental tenets of our Constitution and fundamental principles derived therefrom, then that legislation must fall per se. Now, what is this prejudicial stereotyping that we are suggesting? And how does that relate to 456-250? Underlying this statute is a thesis that subverts and underlines basic tenets of our civil justice system, tenets which are constitutionally based. Number one, the common law permits non-economic damages as legitimate. Granted, they are not subject to the same mathematical certainty as other types of damages or empirical proof, but we have provided a formula that permits juries to consider them. And neither this court nor the legislature in Chapter 305 said that will no longer be the law of this state. Secondly, juries are, where requested, the ones who set damages, including non-economic damages. It is an inviolate right, and our whole civil justice system is premised on the notion that they can do that adequately and competently under the court's supervision. The third tenet involved, courts in some instances themselves determine non-economic awards. The system presumes courts are competent to do that. Moreover, courts sit in a supervisory role over juries And the system presumes that if the jury is a renegade one or errs, that the court, the trial court, in exercise of its supervisory power under fairly restrictive constitutional principles, will correct that verdict. So we have the right to trial by jury, the court's supervisory powers under the separation of powers doctrine, the common law entitlement to non-economic damages, which I'll get to in a moment as to whether that's constitutionally based. Those three principles. And there's a fourth one, and that is that this court did say in Hunter that there is a substantial property right in entitlement to recover for personal injury. We urge that this court should go further now, and this is an appropriate occasion for finding that right constitutionally based and arising out of a host of provisions found in Article 1, our Declaration of Rights. These include Sections 1, 21, 29, 30, and 32. Section 1 saying that the political power is reserved in the people and the purpose of the Constitution is to preserve individual rights. Section 21 providing for the right to trial by jury. Section 29 saying this Constitution isn't just aspirational, it's mandatory. Section 30 saying anything, just because we enumerate some rights doesn't mean the people haven't reserved all other rights. And lastly, the fundamental principles, Section 32. All of the principles of our civil justice system and the state constitution are undermined by this act. Look at the briefs of respondents. You will find them riddled with claims that non-economic damages are subjective, speculative, and standardless. That's inimical to the common law of this state. It was not the basis for the legislature's action here. It is only their way of trying to defend what happened in violation of the Constitution.
Counsel, is there any limitation that might be constitutionally okay? In other words, say it's $5 million instead of this formula they used. Is your argument against the relatively small cap? When have you had a large cap?
It would make no difference.
Your argument be the same?
Yes, Your Honor. The subtext of 456-250 is that juries are unreliable. That is antithetical to our Constitution. And so are the courts unreliable in monitoring and supervising jury awards. Again, inconsistent with the basic fabric of our constitutional law. These constitute, we submit, stereotype prejudgments, which formulate the basis, the underlying basis for trying to sustain this invasion of the right to trial by jury, this invasion of the court's separation of powers, and denial of privileges and immunities. And I think you have to keep in mind that this is all in the context of an act that did not say, as a matter of substantive law, we are changing the notion of damages in this state. It left the common law intact. So it undermines the common law principles that remain in this state. Now, the other aspect of Professor Schumann's analysis on pseudoclass is to suggest an unfair limitation to access gives rise to a constitutional violation. And we would simply submit that here only non-economic damages are subject to the cap. Only tortfeasors who cause those kind of damages have the immunity when you reach that threshold for the cap. Lastly, I would ask the court to look back at a 90-year-old case, Dennis versus Moses, privileges and immunities case, which condemned an attempt by the legislature to say if you foreclosed on a mortgage, you didn't get a deficiency judgment. And it did it on the basis of class legislation.
Thank you, Mr. Hartnell. The court's going to take the recess now rather than interrupt Mr. May's presentation. 15 minutes. Mays.
Thank you, Your Honor. For the record, I'm Bill Mays from Tacoma, and our law firm represents Eagle Pitcher, one of the defendants and respondents herein. Preliminarily, I'd like to indicate to the court that the other counsel who will be arguing on behalf of respondents include Mike Madden from the Attorney General's office and Steve Johnson, who represents Fibreboard and other defendants. We have agreed amongst ourselves on a division of time. I will take the initial 25 minutes, Mr. Madden will take 15 minutes, and Mr. Johnson will take 20 minutes. Preliminarily, let me say that I would like to address my remarks to the constitutionality of the statute and avoid the issues raised by the cross-appellant. Mr. Johnson tried the case. I would like to defer any questions with regard to those issues to him. As Mr. Stritmatter has most eloquently indicated to the court, this is a very important case. This is an important case not only to injured plaintiffs, but I think it's an important case to the citizens of the state of Washington. I reject Mr. Stritmatter's suggestion to you that this only benefits the rich and powerful. When you consider the numbers of people, small businessmen and individuals, who told the legislature the problems that they were having, I do not believe that in any way this statute is designed to only assist the rich and powerful. There are two basic challenges to the statute. One is under our Washington Constitution, Section Article 1, Section 21, which says the right to jury shall remain inviolate. And the second is that the statute violates Article 1, Section 12, the so-called Equal Protection or Privileges and Immunities Clause. Before discussing the two challenges, I think it's important initially to examine the problem which was perceived by the legislature and the solution which the legislature chose. You will recall from the briefs that the legislature had in front of it first the report to the legislature from the Joint Study Committee on Insurance Availability and Affordability, the so-called Marquardt report in November of 1985. Further, the legislature had before it the report of the Tort Policy Working Group of the United States Department of Justice in February of 1986. For instance, the Marquardt report found that there was an insurance crisis. The Marquardt report found that some reform of Washington tort law appears to be needed. The Tort Policy Working Group indicated that the problem essentially was one of non-economic damages because they are inherently open-ended, they are essentially subjective, and they're highly inequitable. And they compared it to a lottery. And in fact, I think there is great truth in that fact. Anyone who has tried very many jury cases knows that there are a number of factors which may in fact affect a jury verdict. And whether or not the plaintiff is severely injured and the extent of that injury is only one of the factors. The personality of the plaintiff, the makeup of the particular jury, and certainly the makeup of the plaintiff's attorney who is arguing the case, and hopefully perhaps maybe the defense lawyer also may have some role in this. Anyway, the Tort Policy Working Group recommended that we limit non-economic damages to a fair and reasonable amount, and they felt that that reasonable amount would be $100,000. Then, of course, we have from the legislature the preamble to the Tort Reform Act, which I think is very significant because I know this court in other cases looks to the legislature and looks to the preamble for guidance as to what they perceive to be the problem and what they felt would be the solution. I point out that in the preamble it says the purpose of this chapter is to enact further reforms in order to create a more equitable distribution of the cost and risk of an injury and increase the availability and affordability of insurance. Then they talk about the problem of counties, cities, and other governmental entities. They talk about the problem of professional liability insurance. And then they also say general liability insurance is becoming unavailable or unaffordable to many businesses, individuals, and nonprofit organizations in amounts sufficient to cover potential losses. If I may, let me digress for one moment. I happen to be on the executive committee of Annie Wright School, basically a girls' school in Tacoma. And you have no idea what a problem insurance is for a nonprofit organization until you have to deal with it. Whether or not this statute in fact will assist in that problem is still undetermined, but at least the legislature felt that this would provide some help in solving this problem. So finally the legislature said, it is the intent of the legislature to reduce costs associated with the tort system while assuring that adequate and appropriate compensation for persons injured through the fault of others is available. Now, I think the next thing which needs to be considered are the rules which this court has set down to evaluate legislative action. First, let me call your attention to a quote from School Directors versus Department of Labor and Industries, a 1973 case of this court. Quote, at page 374 and 75. The wisdom, necessity, or expediency of a legislative enactment is not subject to judicial review. And I think, without going into great detail, but let me call to the court's attention the very recent quote in the State versus Bremen, which was decided in March of this year by this court. This court said, quote, the state legislature may prescribe laws to promote the health, peace, safety, and general welfare of the people of Washington. Going on. Broad discretion is thus vested in the legislature to determine what the public interest demands under particular circumstances and what measures are necessary to secure and protect the same. And then it says, a statute is a valid exercise of police power if it, 1, tends to correct some evil or promote some interest of the state, and 2, bears a reasonable and substantial relationship to accomplishing its purpose. And finally, a legislative enactment is presumed constitutional, and the party challenging it bears the burden of proving it unconstitutional beyond a reasonable doubt. Now, I think those are important considerations for this court in considering what the legislature perceived the problem to be and the solution which the legislature chose. It is very true that the Washington legislature did not attempt to solve the problem in the manner in which other states did. In our brief, our initial brief at page 9 to 13, we cite each of the statutes. I have gone through there, and I believe there are 28 states which have some type of cap. New Hampshire, interestingly enough, has passed 2 statutes. They passed one, it was held unconstitutional, and recently have passed another one. It is interesting to me that 19 of those statutes were directed only to medical malpractice cases. And 10 of those statutes limit total recovery. Now, realize how different the Washington statute is from those other jurisdictions. Our statute applies to all plaintiffs in all personal injury cases. There is no ceiling on economic damages. And third, and this is very interesting, the Washington statute is the only statute in the United States which adopted a sliding scale. As I will discuss later, I think that makes our statute not only unique, but better than the statutes of other states. Now, let me go on to discuss the right to jury trial. Basically, the plaintiffs say that there was a right, that the question of whether or not you have a right to jury trial depends on whether there was a right to jury trial as it existed at the time the Constitution was adopted. It was interesting to me, however, to read the case of State versus Schaff, which is in 109 Washington 2nd at page 1. There, the issue was whether or not a jury trial needed to be afforded to juveniles under the new Juvenile Justice Act. It was pointed out in that case that at the time of the adoption of the Constitution, in fact, juveniles did have that right. Nevertheless, the legislature took away that right, and this court upheld that statute. Now, first, I don't, when the appellants talk about jury trial, it's clear that they do not mean abolishing the jury trial, because clearly that is not what occurred. And for that reason, I think, for instance, cases like the Molodai Court case in Oregon are inapplicable, because obviously, in that case, what they attempted to do, and in the early Washington case cited by counsel, they attempted to take away totally the right to a jury trial for damages. This is not what the legislature did in this case. What I think the plaintiffs are really arguing is that somehow the judgment that is entered, the recovery which the plaintiff obtains, needs to mirror the jury verdict. That's basically what their argument says, is that if the jury says X dollars is an appropriate award, then the judgment should be entered for X dollars. But let me point out to you the various situations in which that is simply not the case. For instance, in the workman's compensation cases, that statute was challenged on a jury trial basis in 1911, and the same argument was made, that both the employer and the employee have a right to submit to the jury both the question of the right to recover and the question of the amount that may be recovered. And this court said no. In these cases, they still have a jury trial. The jury determines the right, but the legislature sets the amount. Let me point out also the situation with regard to remittiture and additure. In those situations, a jury determines an amount of damages, but if the court feels that either the award is a result, if the award is a result of passion and prejudice, either too high or too low, the court has the right to grant either a remittiture or an additure. Historically, it was interesting to me to read the case of Capo versus Van Wieringen in 36 Washington 2nd, because in that case, they talk about remittiture and additure. I had always thought that remittiture and additure dated clear back to the common law. But in fact, as of the time of the adoption of the Constitution in the state of Washington, there was in fact a statute which prevented additure. It allowed remittiture but prevented additure. It was not until 1909 that ultimately the statute was changed to permit both, and in fact now, as we all know, under this court's rule, I think it's 59A, on the basis of grounds for a new trial, both remittiture and additure can be considered. But the point is simply this, that from the standpoint of the jury, if you want to talk about the right of the jury to believe that what they are doing is what is going to be reflected in the ultimate judgment, that simply does not happen. If the judge determines that either that it's a result of passion and prejudice, he can grant a remittiture or grant an additure. By the same token, the situation with regard to substantial justice. It has always been the rule that no matter what the jury does, if the trial judge determines that substantial justice has not been done, the trial court can eliminate the verdict and grant a new trial. I might also point out the same thing is true in treble damage cases. The jury comes in and they decide that a fair award to the plaintiff in this case would be, we'll say, $100,000. But that's not the judgment that is entered. The judgment that is entered, the damages are trebled, and the judgment is $300,000. Again, would the plaintiff say that this violates the right to jury trial because by some policy of the law we treble the damages? I might also point out to you, not in the damage situation, but in the joint and several liability situation, we have substantially the same situation. The jury, we will assume in a case, finds defendant A 90% negligent and defendant B 10%. They then award $1 million damages, assuming that defendant A is going to pay $900,000 and defendant B $100,000. But in fact, if defendant A has no funds from which to satisfy the judgment or no policy of insurance, we all know what happens. The jury might be very surprised to know that defendant B, who was only 10% negligent, actually ends up paying 100% of the judgment. Well, I think there's one other situation also which may, to me at least, substantially impair the right of a jury trial, which has been upheld. And that's in the situation with regard to mandatory arbitration. The legislature in RCW 7.06.060 authorized this court to make rules with regard to attorneys' fees and costs in the event that the appellant from an arbitration case did not better themselves in a trial in the court. And in fact, this court adopted MAR 7.3, which does exactly that. So what that means is that if I have tried a case in arbitration and don't like the result, and I want to go ahead and go on to have a trial de novo, I'm running the risk of having to pay substantial attorney's fees and costs on appeal. That very issue was raised in Christie Lambert versus McLeod, a Washington Court of Appeals case in 1984. And that court held that this was not an unconstitutional restriction on the right to jury trial. It was also interesting to me in reading some of the cases from other jurisdictions to note that in the Indiana situation, as I'm sure this court is aware, 3 states have upheld the caps under varying circumstances: California, Nebraska, and Indiana. It's also interesting that, from what I understand historically, the Washington Constitution is taken substantially from the Indiana Constitution. It went from Indiana to Oregon to Washington, as I understand it historically. Be that as it may, the Indiana cap, which was, as I remember, limited to medical malpractice cases, was upheld by the Indiana Supreme Court on a basis that it did not violate the right to jury trial. Now, counsel, in their argument, anticipated one of our arguments, and that is that if, in fact, the legislature can abolish a cause of action, then why can't the legislature limit damages? And let me say that I'm not sure that that is limited to the legislature. I assume that when the Constitution says that the right to jury trial shall remain inviolate, I assume that means that neither the legislature nor this court can do anything to prevent the right to jury trial being inviolate. Well, let me point out to you that first, with regard to the legislature, we know that the legislature eliminated a cause of action in the workman's compensation situation. We also know that the legislature, in I believe 1973, eliminated a cause of action with regard to crime victims' compensation, which was upheld by this court in Haddenham versus State in 87 Washington 2nd. We further know that the legislature abolished contributory negligence when they enacted RCW 422.020, and this court upheld that in Godfrey versus State. And then we have the very recent case of Daggs versus Seattle, which is 110 Washington 2nd, 49, again, February of this year, in which this court said, a tort victim has no vested right to recover the amount of damages allowed under the common law before the damage limiting provisions of Tort Reform Act took effect. Well, we can all think of other situations in which this court has in fact affected damages. I point out to you this court's case in Harbison versus Park Davis, where this court created a cause of action for wrongful life, but limited the damages to special damages, only extraordinary expenses, and said, no, you can't have general damages in that kind of a situation. Likewise, in McKiernan versus Ashheim in 102 Washington 2nd, this court said that no, there will be no damages for the cost of rearing and educating a normal child, because that's against public policy. Likewise, in Kirk versus Washington State, this court held that the loss of enjoyment of life is a separate item of damage, and in fact added an item of damage. I guess my question would simply be this: if the court and if the legislature can do that, then why couldn't the legislature in this case have simply said, okay, look, we think the verdicts for general damages are too high, therefore we're going to reduce it, not by putting a cap on it, but let's say we'll eliminate all non-economic damages except pain and suffering. We'll do away with emotional distress, mental anguish, loss of enjoyment of life. I don't hear any argument as to why the legislature could not do that, and yet that would in essence have the same effect as what occurred here. Well, let me move on to equal protection in the brief time that I have left. Let me respond to appellants in this manner. I recognize that this court has suggested that this court might adopt the Oregon methodology of evaluating equal protection cases. As most of the members of this court know, I'm not really a constitutional lawyer, and it's been somewhat fascinating to me to read all the cases involving equal protection. But the thing that I find is that this court, over a period of years, and particularly very recently, has adopted a pretty good methodology of ruling on equal protection cases. And this may be old-fashioned, but I've always thought if it's not broke, why fix it? My argument is simply this. It seems to me that we have a very valid way in which to analyze equal protection cases under the strict scrutiny and under the minimal scrutiny case, and in only one situation, the intermittent scrutiny case in State versus Phelan. If that is the case, and if this court is able to analyze equal protection cases in that manner, then I suggest to the court that there's no reason to change and to go off and adopt an Oregon methodology which would create great indecision amongst legislatures and trial judges as to what analogy now should be applied. Therefore, basically it is our position that in this case, this court has, in almost every case involving economic legislation, held that the minimal scrutiny is the proper test. And I think that under the minimal scrutiny test, this statute clearly meets the minimal scrutiny test as set out by this court. I'm standing here afraid that red light is going to go off, so I'm going to stop. Thank you.
Thank you, Mr. Mays. Mr. Madden?
May it please the court, my name is Michael Madden, Assistant Attorney General, and we appear here today as amicus on behalf of the state. There are two primary concerns that bring us here today. The first is our responsibility to defend statutes enacted by the legislature, and the second is our duty to defend tort claims filed against the state of Washington. Now, I'm from the Tort Claims Division of the Attorney General's office, which seemingly lines me up with the defense side of the aisle, but I don't think that this is a defense bar or a plaintiff's bar case, because after all, big verdicts benefit both sides of the bar. But it's my intention here to supplement the able arguments of other counsel from a perspective that I believe is a little bit different from the other parties. First of all, this is not the only statute which our office will be called upon to defend, and we're concerned that the appellant's attempt to constitutionalize tort law will upset some long-standing and settled understandings both within this court and in the legislature as to the power to modify and shape tort law over time. We're afraid that this will lead to a period of uncertainty in a field where certainty and predictability is perhaps the highest value on both sides. We're afraid that this period of uncertainty is going to be inimical to the 1986 legislature's goal of trying to bring certainty to the law. And as I listen to the arguments today, I feel that even amongst the appellants, they can't agree which test to apply. And they certainly don't tell us where it will take the court and the legislature in the 100 years to come that Mr. Harnetow mentioned. Now, secondly, as a tort litigant, we're familiar on a first-hand basis with some of the factors that made such a persuasive case to the 1986 legislature when it enacted tort reform. And the state, I believe, provides a pretty good example that we can talk about on a hypothetical basis, although it's not a hypothetical, as to why the legislature would look at this cap as a beneficial measure, particularly for governmental entities. Prior to 1979, tort liability was a minor blip on the state's fiscal horizon. Most of the business came from the Highway Department, automobile accident cases, and to my memory, there were about 6 lawyers doing tort work full-time. Since that time, our liability has increased. There's been introduction of some new theories of liability. Our payouts have certainly gone up, whereas prior to 1980, I think we had $1 million verdict. Those kind of verdicts and settlements are not all that uncommon anymore. Maybe most graphically, there are now 28 lawyers doing tort defense work full-time for the state. And the nature of our liability is perhaps a little bit different than what you would usually see. It's not necessarily direct liability where a state agent directly causes the harm. More often, it's alleged that the state has failed to do something to protect against harm caused by a third party, such as the failure to erect a median barrier to prevent the drunk driver from crossing over into oncoming traffic, or the failure to adequately supervise a parolee, or to detect a child molester in a licensed daycare center. These types of cases are our typical big claims, and particularly in the law enforcement and corrections area, they consist in large part of non-economic damages, which can be very, very difficult to measure, can vary widely from case to case, and therefore make risk management an extreme challenge. Now, the example that I'm giving you of state liability, and I believe it applies as well to local governments who are a big part of the tort reform movement, does not depend on insurance, because the state and now many of its subdivisions are not insured. We don't purchase insurance. But the availability of insurance to others certainly does have an effect on us, because whether or not the state or some other governmental entity is brought into a case very often depends on whether the person directly causing the harm has insurance or enough insurance to cover the loss. If they don't, then it's more likely that the state or other governmental entity will be in the case. The 1986 legislature, we believe, was responding directly to this kind of dynamic when it looked at tort reform, and you can find clear mention in the preamble of allusion to this type of problem. Now, the cap is nothing new, as has been pointed out by appellant's counsel. Many states have enacted broad-based caps, either for medical malpractice or otherwise, in recent years. But the history of caps goes beyond that. I believe a majority of states have caps on governmental liability. Oregon, I know for sure, has a cap of $100,000. Their tort operation doesn't look anything like ours. But
of course, the state has to consent to be sued. And in this state, there was a time in the legislature when the state did make that decision. We will consent to be sued, and passed a statute to that effect. So I suppose in those jurisdictions, if they're at all like ours, they just withdraw some of that dissent. There's some of that consent. We consent to be sued up to so-and-so or something. But isn't that a different sort of a thing?
Well,
No, I don't know.
I would think so.
Because I was in the legislature, so was, I think, Justice Dorr, maybe Justice Brockbach. At the time, the state made the decision
to waive.
We hereby consent to be sued.
Right. And the rationale, you're exactly correct, in most states
and we waive sovereign immunity.
Is that the waiver of sovereign immunity may be conditioned upon a cap.
I would assume that's what they...
Although one would also, I presume, have to look at that cap from an equal protection standpoint if indeed the right to recover damages is protected.
I understand you're self-insured.
We are not self-insured in the artful use of the term. We are pay-as-you-go.
And the legislature, when they enacted this legislation, did not contemplate any protection for self-insured people.
I would not agree with that, Justice Dorr.
Well, I thought I read the preamble, it said that in order to cut insurance rates, that was the purpose of it, because it was not available to local governments and so on.
That is certainly...
But it's certainly, there's no mention of self-insured, because that wouldn't be its purpose. So
No, but it...
actually, the Attorney General really doesn't have a stake in this case, do they?
We have a direct stake because many of the provisions of the Act have a direct impact on state tort liability.
But
But
what I'm getting at is you're not within the contemplation of the purpose in passing legislation to cut rates so local government can get insurance.
I agree with the premise that the sole purpose of passing the legislation was to cut rates. I think that in context, the cap in context with the rest of the Act reflects some strong legislative judgments about the direction in which our tort system was going, and you'll find in the preamble the legislature's reflection upon the equity and the costs associated with the system, of which insurance is a major component.
So your representation to us today is that it also was in the contemplation of the legislature they wanted to protect self-insured entities too.
I would agree with that. As I said, in context, we believe that the intent and effect of the cap is similar to the other components of the...
Before you pass on that last...
Yes, Justice
response,
Anderson.
You're not saying self-insurance, you're really just uninsured.
We are uninsured. We are pay-as-you-go.
And as are an awful lot of other people.
Correct. There are some state agencies with minor qualifications
Yes,
that
that
technically
have-
self-insure,
yes.
but the state in general does not.
What's the difference between uninsured and self-insured? You
Self-
don't have any, you're uninsured, and you're also self-insured. So
Self-insured's reserve funds in advance for predicted losses.
it may not be that at all. You don't have any funds.
Certain state agencies do self-insure in the technical sense of reserving funds in advance of the claim maturing. The intent and effect of the cap, we believe, was, as with the other components of the Act, to promote activities that the legislature thought were socially desirable by reducing the cost, be it insurance or direct payout of verdicts and settlements, to those actors. But the cap deals particularly with a problem for deep pocket defendants, because the reality of personal injury litigation, as I'm sure you know, is that policy limits most often define the amount of the recovery. No one seeks $1 million verdict against someone who has only $100,000 worth of coverage. But that constraint doesn't exist with a deep pocket defendant such as the state. And in that case, the stakes go up considerably, and the ante is usually non-economic damages, because those are the big unknown in the case. That as counsel Mr. Mays mentioned, a wide variety of factors can influence the outcome on that particular issue. With economic damages, at least you know somewhat in advance, and you have an experience with the experts and other similar cases to predict where you're going to come out with on the economic loss, but it's extremely difficult to do it on non-economics, and if you are wrong, you can be really wrong. And that is the fear that I think the legislature was reacting to when parties who have this risk exposure came to them and said, we cannot manage this because the whole system is driven by the fear of this huge award. Now, the appellant's response, I understand it to be, to that point, to be it's unfair to penalize the most severely injured because it is those persons whose awards you will cap. I would point out first that by their own admission, the cap does not affect the vast majority of cases. The cap provides a range that is now in excess of $600,000 for an infant for non-economic damages, and does not affect at all the myriad of economic damages which can be recovered.
Do you have any idea how large that class is that's being excluded for severely injured, percentage-wise or dollar-wise or any way?
No, I don't.
Do you have any?
I have no way of saying that, because I believe...
Plaintiffs' briefs indicate there's 5 or 6 cases of that nature. Is it something relatively small, under 5%, or is it half? Or?
I believe you cannot say, because you cannot predict with any kind of significance what case is going to go is going to fall into that range or not until it matures.
But you've had 2 years' experience now. How large is the class?
Well, our experience is still with cases which were under the old law, and I don't believe we have had an experience with a catastrophic injury case.
Approximately, whether it's accurate or not, what is your experience? What percentage is in this disabled category?
I'm sorry, Justice Dorr, I'm really unable to answer that because I would have to reflect on the ages of all the plaintiffs in the